Welcome back to Asset Management Overview, Asset Management Regulatory Overview. This is presentation number 4 of week 5, and we are following up on our last presentation on the revised DOL fiduciary rule, conflict of interest rule. It's called many things. And during that presentation, we discussed the best interest contract exception. So I'd like to follow up on that discussion and discuss the topic a little bit more deeply, should we say. As I mentioned in the prior discussion, the DOL fiduciary rule is definitely in flux. So it is something that is not quite yet effective, but it hasn't been implemented, and now it has been delayed. So the rule itself, there's no requirement to implement changes in your regulatory scheme if you're if the rule is applicable to your business. Nevertheless, as I mentioned, many firms have already implemented good portions of the new fiduciary rule as a matter of a best practice, and therefore it may become more of a customary standard, even if it's not the regulatory standard. And even so, there have been various lawsuits working through the judicial pipeline concerning the concept of best interest and looking out for the clients, fiduciary principles in this particular arena. So even if there isn't necessarily a regulatory rule, there can still be legal action. So I want to now further discuss the best interest contract exemption that we discussed in the last presentation, so you can have a better idea of exactly what's required and how it works. So let's get started. So as I mentioned during the last presentation, there are various exceptions under the fiduciary rule, and the best interest contract exemption, also known as the BICE, is one of those key exemptions that has been a hot topic or a hot button. Essentially, the best interest contract exemption reflects an effort to align an investment advisor's interests with the client's interests, and in doing so requires a written contract with certain elements, conflict of interest policies and mandates, and precludes certain other activities. So if we take a step back, the DOL conflict of interest rule, most advisors who provide investment advice for a retirement account specifically would need to rely on this new best interest contract exemption in order to conduct and be compensated for retirement workflow business. As I mentioned a moment ago, the BICE, or the best interest contract exemption, aligns individual advisors' interests with those of the retirement plan or IRA investor, while leaving the advisor and firm some flexibility in designing a business model that best serves their retirement clients. Rollover recommendations in particular, which are now characterized as fiduciary investment advice, will require advisors to comply with the best interest contract exemption. Specifically, the BICE allows firms to continue to use certain compensation arrangements that might otherwise be forbidden, so long as they, among other things, commit to putting their client's best interests first, adopt anti-conflict policies and procedures, including avoiding certain incentive practices, and disclose any conflicts of interest that could affect their best judgment as a fiduciary rendering advice. Many traditional forms of advisor compensation, including commissions and the receipt of 12b1 fees in connection with mutual fund transactions, represent prohibited sources of revenue that create fiduciary conflict, unless a prohibited transaction exemption is available to permit the receipt of those payments. So one purpose of the best interest contract exemption, or the BICE, is to exempt the receipt of commissions, 12b1 fees, and other forms of third-party compensation received in connection with rollover recommendations and other forms of investment advice to plan participants and IRA holders. So now that we know what the BICE is specifically and what its objective is, what are the best interest contract exemption requirements? What are the requirements of the BICE? Well, according to the Department of Labor, the best interest contract exemption will allow firms to continue to set their own compensation practices as long as they, among other things, commit to putting their clients' best interests first and disclose any conflicts that may prevent them from doing so. Broker-dealers and registered investment advisors need to consider how they will comply with the best interest contract exemption. In most cases, firms will need to discuss very specific information in a mutual contract with retirement investors. That's supposed to begin January 1st of 2018, but again, given the current state of this rule, that's a bit unclear. But nevertheless, for not only an intellectual exercise, but to understand all of the terms and conditions of the DOL fiduciary rule, it's important to understand the subject matter, as it may still change whether or not the rule itself is scrapped. So how do we implement the best interest contract exemption requirements? Well, first off, you state the best interest standard that will be provided by the firm and advisor. Then inform investors of the services that will be provided by the firm and advisor. Also, explain how investors will pay for services directly or through third-party payments. Describe material conflicts of interest, including any fees or charges the firm, its affiliates, or the advisor will charge investors or their retirement accounts, and the types of compensation that the firm, its affiliates, and the advisor expect to receive from third parties in connection with investment recommendations. Also, it's important to inform investors that they have the right to obtain copies of the firm's written description of its policies and procedures, as well as specific disclosure of costs, fees, and compensation, including third-party payments. Next, it's important to include a link to the firm's website, which must include the model contract disclosures updated on a quarterly basis and the firm's written description of its policies and procedures. Also of note, it's key to disclose whether the firm offers proprietary products or receives third-party payments with respect to any recommended transaction, and if investment recommendations are limited in whole or in part to proprietary products or investments that generate third-party payments. Also, it's important to provide investors with contract or contact information for firm representatives so that there's clear communication, and also to describe how the advisor and firm will monitor investments and alert investors about any recommended changes, as well as the frequency and any other reasons for alerts. So if we want to also take note of the streamlined best interest contract exemption for level B fiduciaries, we'll see that a streamlined version of the best interest contract exemption is available for level B fiduciaries who provide rollover advice to plan participants or any retirement investor. And what's required is a written statement of fiduciary status, compliance with standards of impartial conduct, meaning providing advice in an investor's best interest, receiving reasonable compensation for transactions, and not making materially misleading statements to investors about recommendations. Also, written documentation of the reasons why the rollover recommendation may be in the client's best interest. So, in sum, for the majority of the firms, restructuring of individual investor or an individual advisor compensation is a key component of compliance with the best interest contract exemption. And the challenge would be to create compensation structures that properly reward productivity while assuring individual advisor adherence to the impartial conduct standards. And that, in sum, concludes our discussion of the best interest contract exemption, or the BICE.